Tune into my show, Bulletproof Estate Planning, on WDXE in Lawrence County on 105.3 and 95.3 FM every Friday morning from 8 to 9 a.m. This is the show where we discuss everything estate planning: last will and testament, living trust, special needs trust, asset protection trust, and 10-care eligibility. See you Friday morning for the next episode of Bulletproof Estate Planning.
Well, that's us, and we're here right now.
We are.
I thought that might have been what we're supposed to be, but that's your regular commercial.
That's right. That's right. Well, anyway. I can send it again if you need me to. It's some intro music that's that I base on a song from the '60s by the Byrds called "Turn, Turn, Turn."
Turn, turn, turn. Okay.
The song is about the Book of Ecclesiastes in the
Yes,
Bible.
it is.
So
it certainly is.
Anyway. Because I like it because it's nothing new under the sun.
Yes.
You know, there's a time for every season and a time for
that's very fitting.
For planning.
A time for planning. That's right. A time for planning, and that's what you've talked to us about for quite some time now. I was telling the guys just before you got in that I've enjoyed our visits on Friday and have learned a tremendous amount. It has caused me to do a lot of thinking about what we're doing, what we need to do, that kind of thing, which has been very, very helpful. Very helpful, and
good.
We're turning the ship in the right direction.
There you go. Well, I was listening to the hour before, and it sounds like you had a good Christmas. I'm glad you did.
Yeah, we did. We had a nice Christmas. Hope you did, and of course, we're winding up the year, Stan.
Yeah.
This is our last show of this year.
It is. And I was over at WKSR yesterday morning.
Yeah.
And Butch was out sick, but this was his last week on the air, and Ed was going to be doing the morning show from now on.
Oh, okay.
And so it was a little different, but we, same thing. It's 2024. It's 2024 has not been written yet, so let's make it a good one.
Let's make it a good one. Do our best.
That's all we can do. And maybe mistakes we made, we'll try not to. Best you can do when you make a mistake is not focus on it. Just learn from it and try to prevent reoccurrence.
That's right.
It's not a. I've never been one when something goes wrong, something happens in the office or something happens at the house, and it's not a big deal. I don't like to get into the blame or pointing finger. It's like, all right, if this happened, why did it happen?
Yeah.
What can we do to keep it from happening again? It's the only way to approach it. So.
Right, exactly.
So the same thing happens with in law and legal and planning. Sure. If something isn't right, we can fix it. So. Listen, I'm going to start out about my seminar coming up. Of course, remember, this one's in Franklin.
Yes.
And it's in 2 weeks, roughly. So it's 2 weeks from Saturday, I guess. It's the January the 13th. And it's going to be up in Franklin at a place called Suite 501. The actual address is 416 Mary Lindsay Polk Drive in Franklin, Suite 501, Franklin, Tennessee. So if you want to come to that, you can put that address into your GPS. It'll get you there. It's a real nice place, a little on the south side of Franklin, and a little more out in an industrial park area than it is like downtown or something.
Yeah.
But a nice place. Seating is somewhat limited. I can hold about 50, and that's 40 to 50 is usually where the attendance comes in at. But they have tables with chairs around them. So if we get walk-ins or get over that number, we can put up a table and just put some chairs more a little theater style, where you just sit and watch. So anyway, it's a real nice place. It's one of those places that got big old TV screens everywhere. I just got to show it with my laptop, plug in, and my PowerPoints. I mean, I don't care which direction you're sitting and looking. There's a TV in that direction.
That's great.
Yeah, it's cute,
set up for just that purpose.
It is. Yeah. It's a nice place. So anyway, give my office a call at Pierchoski Estate Law, Pierchoski Elder Law at 931-363-7222 and get on that RSVP list, or you can go to my website, which is estateplanstan.com, and you can see the calendar. I think you can RSVP from there.
It's a catchy website.
That was one of my team came up with that idea, and it worked very well because some folks complained they couldn't find my website because they kept trying the spelling, and eventually they hit on something that got close enough to get them there. But that you can't get easier than that. So
that's better, much better.
Yeah.
And the phone line's here, by the way.
I was just thinking that. Yeah. Why don't you go ahead?
Well, yes, the phone line's here, 931-766-9393. And, of course, Stan will take your phone calls throughout the morning here while we're together up until 9 o'clock. And we'll be talking estate planning and anything else that we might want to bring up for that matter. Yeah. But the lines are open to you, as always, 766-9393 is the number here.
And I do want to say that I encourage that. I encourage questions. If you have them,
Yes.
please just ask. I'll be more than happy to answer them. That's one of the reasons that attracted me to do the show here. When you folks went to talk radio and
Yeah.
Miss Charlotte approached me, it seemed like a good opportunity, because when I have my seminars, the questions just abound. Okay?
Yes.
I always take the position that at the end of my seminar, I stick around for the question and answers, and I'll be the last one out the door until the last question is asked.
Yeah,
and
absolutely.
people have plenty. They have plenty.
Yeah.
And a lot of them have the same question. So when they
Yeah.
ask them in a group, it's usually very helpful. So
Yeah.
again, if you hadn't been to one and you have a question, it's okay if it's been asked before.
Well, I'll tell you some personal experiences here. From my conversations with you, it has sparked conversations at home. Okay,
yeah.
so in I just last night, as a matter of fact, we were talking in this arena of estate planning and some family matters and things like that. And some people find it really difficult to talk about. It dawned on me that for some, it's uncomfortable for them for some reason. They begin to ponder, and they feel uncomfortable dealing with, the what's really inevitable at some point. We're not going to be here. So what's going to happen to our belongings at that point? And it's uncomfortable for people, but they need to kind of get over it. We were having this discussion. This is something that's important for you and your family and your estate. And it doesn't have to be a large estate. It can be your stuff.
Exactly right.
So it's like, I just had to have kind of this conversation with the family that, look, I know this is maybe uncomfortable, but we need to talk about, what's going to happen and what we'd like to happen.
Absolutely.
Yeah.
And you're right. You're sort of talking about your mortality.
Yeah.
Okay. Kind of like my theme song, The Birds.
Yeah.
Turn, turn, turn.
Yeah, exactly.
There's a time for every season.
Exactly.
There's a season to be elderly and to not be here anymore. I mean, we
Yeah.
all know it, and nobody likes to think about it. We don't know when, but we all know it.
Right.
And it can be talked about. It needs to be embraced.
That's right.
And it kind of. I was going to start with a question that Ed over at WKSR at the end of my. I only got about 10 minutes over there, just on the bonus hour, and he had a question.
Yeah.
And he said he gave it to me at the very end and said, when we come back next Thursday, answer my question. I'm going to let this conversation dovetail right into that, so I'll answer that question over here, and then it'll be next Thursday until I answer it over there. But
yeah,
it's hard to talk about, and people don't want to, and they may want to avoid it, but because it's uncomfortable. Let me tell you what's more uncomfortable. Not talking about it, not doing anything. I mean, I continue to experience things that happen with families and people that don't get around to doing anything. And that's what Ed's question was. Ed's question was, what if you have somebody, and he tells all his kids, and he tells, like me, I got 3 kids, and I tell them what I want to happen when I'm gone, and I am just absolutely crystal clear.
Yes.
I want this here, this here. I mean, just everything. And even some of the other things, like how I want buried and what I want done with my ashes, if I want cremated, stuff like that. And let's just say I'm just crystal clear, and there's no misunderstanding among my children what I want.
Right.
What happens in a situation like that? Well, let me start off with this. In an ideal world,
yes, in an ideal world,
if everything was perfect, it would work that way.
Yeah.
They would do what I ask them to do.
Right.
But now, if you start getting out of the ideal world, which we are far from,
yes.
Now you stop and think about it. Who has the authority to distribute my stuff? Just because I'm gone doesn't mean it's still not mine from a legal standpoint. Now, if we would go back 200 years or something, you pass away, you got stuff in the house. I mean, the family just continues to use it. I mean, it's just not like that anymore.
It's not.
Unfortunately. And so, from the legal standpoint, if you pass away and they have instructions on what to do, it's still my stuff. Okay, so it depends on what you're passing. Now, if it's the stuff in the upper right-hand drawer of my desk, okay, pens, my letter opener, my stapler, stuff like that, you can see that there's no real issue with that kind of personal property.
Right.
And as the personal property gets bigger and more valuable, it could pose some more concerns. But certainly, it's an issue when you deal with real estate.
Yes.
Real estate has gotten to the point where ownership has to be clear. It should be made part of the public record, and it has to be by deed. I mean, that's the only recognizable ownership that we have is by deed. Even if you we have you hear people talk about squatters' rights. You know,
Yes.
there's a way to attain property by what's called adverse possession.
Yes.
It's kind of a tough road to hoe, but you can do it even
Yeah.
today. And if you attain property by adverse possession, I mean, there's no deed, but it takes a court to determine that.
Right.
And if you satisfy the 7 indicia of adverse possession, and the court grants you that property, the court will order a deed.
Can happen, but pretty rare.
It is rare.
Yeah.
I mean, it was a little more common in the older days, but
Right.
it can. I mean, if you can satisfy these things.
Yeah.
But the end result is you get a deed. So if you're going to be transferring property from the deceased, because when you pass away, even from our earliest common law, even in scriptures, when you pass away, you have something that we call an estate. Your life is,
Right.
your property still belongs to you, and it needs to be distributed to who you wanted it to go. And somebody has to have the authority to do that. And when you get into real estate, there has to be some legal vehicle that changes the
Yes.
name on the property to the beneficiary.
Right.
And now that doesn't even, so that's a good question it has, but we're starting to get out of the ideal world. And then you throw in, what if it was crystal clear to my kids, but now changed
Yes.
or something? Or here's what's more like it. I don't want to beat up on anybody's children, but a lot of times some people have children like that and they leave things to them accordingly.
Yes.
But here's some other things that come into the mix. What if one of the children, who's perfectly reasonable and happy with what you left them, their spouse is not happy with what you left them? And let's take it one more step,
Yeah.
and let's say that your child is somewhat influential when it comes to the spouse. So now what do you got? Okay, I want to honor Dad's wishes because he wanted me to have this, but I
Right.
also am married and probably have a couple kids, so I have to respect this marriage, and I got to make this thing work, and my
Yeah.
spouse wants me to contest this to get more or something.
Yes.
And so now that person's in a real rock and a hard spot, right?
Yeah.
I can see it. I see it all the time. So all these things, and I could go on forever. And if somebody just wants to plain contest it,
Yeah.
it can get ugly. And so when you say it's uncomfortable to talk about, let's talk about what's more uncomfortable. And that's going to be the day something happens and there's nothing in place to make it easy for these
Yeah.
folks, because that isn't, and you really don't want to wish any of that on your kids. I'm telling you, I've seen it, and most people I talk to say they've either seen it themselves or they've had some indirect experience with it, where a family member, somebody had to be the executor of something, or a close friend.
Right.
And never does anybody ever tell me, yeah, I went through probate and it was just a blast. I mean, and never. Even if it goes smoothly, it's a hassle at most.
Yeah.
If it goes bad, it's a nightmare at least.
Right. Yes.
So the alternative is just almost not an option, in my opinion. But it happens all the time, and I hate to see it because it can cause some real sour feelings among family members. It can burn bridges. I have seen people not talk to each other ever again over a shotgun,
Yeah.
and there's just no way for it to be that way. So when you plan, what you can do, first of all, you can keep them from having to go through all that.
Yes.
Certainly probate.
Yeah.
You can memorialize what it is you want to have done. Of course, when you memorialize it, it becomes enforceable. Now, if somebody's not happy with that, there's not a whole lot they can do about it. But at least, at the very least, you're doing what the person wanted, the deceased. Now, if you have a spouse that wants to say, hey, you need to do more, and if you got this memorialized in like a trust that is a probate avoidance tool, I mean, at least if you're this rock and a hard spot I'm talking about between your dad's wishes and what your spouse wants, well, now the scale's going to tip in favor of what your dad wanted, and that's your perfect out. So listen, I can't. It's memorialized in an enforceable agreement. This is what I get. If I try to attack it, I'll get nothing.
Yeah.
And this is what he wanted. Maybe we like it, hate it, or somewhere in between. But this is what he left us, and this is what we have. This is what we get.
Yeah.
So the whole system, especially when you have a trust plan, is designed to make that so much easier for them.
Yes.
Now, if you're not getting what you want, and it's not easy for you, well, that's not who I'm talking about.
Right. Exactly.
I take the position that it's my stuff. If I want to divide it up, not equally. I got 3 kids. So if I decided I want to do it 10% to one, 20 to another, and 70 to the third, that's certainly my prerogative. It's my stuff, and I'm going to divide it how I think it needs to be divided.
Yeah.
Right? Now, if they're unhappy about that, I mean, I'm just in a position of, I'm sorry you're unhappy about it, but you'll just have to be unhappy.
Yeah.
You'll just have to live with it.
Yeah.
So inheritance is a windfall. There's no entitlement. I
Yeah.
see people fight before the parents have passed away yet.
Oh, I know.
I can't even imagine that. It happens in my office while they're in the room, for crying out loud.
Yeah.
And so, it's a windfall. If they leave you anything, you ought to be thankful for it.
Yeah.
So there's a lot of people that people pass away, they don't get anything out of it.
That's true.
And you're on your own. You're truly on your own. We know that.
Yeah.
You're born in your birthday suit, and by the time you're old enough to take care of yourself, you're supposed to take care of yourself.
Yeah.
There's no take care of yourself, and then someday you'll get this windfall and everything will be great.
Well, you and I have talked about this before. In no matter what you obtain in this world, when you leave this world, it's going to be somebody else's.
Absolutely.
You're not taking it with you.
The question, yeah. The point is, it's not yours, and you're not going to go take it with you.
So you hold on to possessions, I guess, sometimes a little too tight, and it's all for naught.
Well, it's all for naught in the end. I mean, I guess it's
Yes.
useful to you during life, but you're right. You're
Yes.
right. When people get close to end of life, I mean, and you ask them what's important, that's usually not the answer.
That's not the answer.
So, when you plan, you can create a scenario that will be easy for your kids. Okay?
And that's the goal.
And it can be as equal as what you think equal is,
Yes.
what they deserve. And it can be, enforceable.
Yeah.
And I find in this neck of the woods, I belong to some forums and stuff that other states, and I find in this neck of the woods, like in the South, middle southern Tennessee, most families are pretty happy with what the parents leave.
Yeah. Yeah.
There are some intervening forces where people complain, but it's probably not it's probably more the exception than the rule.
Yeah. You're right.
So, but there's a way to do that. So when we're talking about this uncomfortableness, if somebody says, I don't want to talk about this, Dad, because I don't want to talk about when you're gone.
Yeah.
Say, well, let's not talk about when I'm gone. Let's talk about what a hassle it's going to be for you if I don't do this kind of planning when I'm gone.
That's right.
And I'm doing this out of love because, if you come to me, Jeff, if you come and your wife come to me and say, we want to do some planning and a trust plan, I guess theoretically, you're not doing it for you and your wife.
No.
You're doing it for the people you love.
That's right.
Because they're the ones that are going to benefit from what you do. Now, I could say you get something out of it. You're going to get this peace of mind,
Yeah.
knowing that it's taken care of and it's
Right.
going to be okay for them. But from a substantive point of view, I mean, you're doing it for the people you love
That's right.
to keep them out of this and make sure that they get it. So
Yeah.
again, and now nothing upsets that apple cart like people who go into long-term care. I mean, now you have an intervening force during life
Yes.
that will gut an estate. So there's, I don't care if you have the best written revocable living trust or best written will that
Yes.
leaves property to your heirs and is enforceable. If you don't have anything at the time of your death, there's nothing for it to pass.
Right.
So that's why we spend so much time on 10 care eligibility and the asset protection trust way ahead of time, so that we have an estate to leave to them.
Right.
I mean, everybody wants to do that. You can say, well, my kids are on their own. I was on my own, so they can be on their own. But everybody's goal, I think, at least 99% of people are, all right, I've done what I've done during my life. I'm in my advanced years, and I'm ready to, I'm going to give it to you because I want it to go somewhere. I want it to help you out. It's almost like a gift.
Right.
Maybe you need it, maybe you don't need it. But that's what I want for it to do. I want it to go to you.
Yes.
And so if that's what you want, there is a system out there, a system that's just waiting that if something happens to you during life, that will come in and enter your life and enter your financial world and will just clean you out.
Yeah.
And now, even though that's your goal, you pass away, you don't have anything. If you don't have anything, I mean, a will can say I leave everything to my 3 kids, but if there's nothing there,
Yeah.
it's kind of moot.
Right. Right.
And so there's nothing to give them. So, we want to leave it to them. We want it to go to them. But we also want to preserve it, make sure we still have it at death.
Sure.
And like I said, the biggest sleeper out there is this concept of long-term care in a couple ways. One, just the private pay if you have to private pay it during life.
Yeah.
And what you've often heard me refer to as a sleeper is what can happen after death with this estate recovery that they have.
Yes.
After death, they can go after everything there. So we don't want it there. So we want it with the kids. So
Right.
Anyway, so that's
Well, let me ask you about this, and I'll just come up with a scenario here. Let's say that, and you've mentioned the family farm or the family real estate. And of course, real estate's kind of my world, but the surviving spouse has children and they want that farm to be left to her, his or her children. Okay. But they're maybe a long way away from thinking about long-term care yet or anything like that. No health issues at this point, that kind of thing. Do you think it's wiser, and this is, I guess, a discussion, but is it wiser to deed that property to them and maybe keep a life estate, or go ahead and do the trust like you're talking about? Or is there advantage or disadvantage to either or?
Okay, I got you. So there's there's pros and cons to both.
Yeah.
And what you say can be done. There's nothing that says you can't deed it to them now and reserve a life estate.
Right.
The problem. Okay, let's talk about that. Let's talk about deeding it during life.
Okay.
Inter vivos transfer.
Yes.
You're alive, and the person you're giving to is alive, and you're
Right.
giving it to them. And let's say it's going to be a gift. You're not. It's a $500,000 farm, and you're not making them pay you for it.
Right.
So you can give it to them. You can deed it to them. And because once you deed it to them, they own it.
Yes.
So most people say, well, my kids would never turn around and kick me off the land.
Right.
But in order for that not to happen, because a lot of folks say, well, they might, but I don't know about their spouses.
Right.
Because I've seen situations where you left the property to a child, the child leaves it to his wife or doesn't have a will at all and passes away. And now the in-law is in charge, and they have kicked them off.
Yeah.
I've seen it. I
Yeah.
have seen it. So,
Yeah.
so people will reserve a life estate, which is the ability to live there governed by the term of your life.
Yes.
Interesting side note is that, a life estate can be based on anybody's life. You could say it's based on the King of England's life or something. You can.
Isn't that amazing?
I've never seen that done in my practice.
Yeah.
But the law books are clear.
That is true.
So,
Doesn't seem to make any sense, but it's true.
well, I won't get into it, but I can think of one or two very limited reasons why you might want to do that. But again, it's really not for you to actually live there.
Right.
So typically it's your life or you and your spouse's. And it guarantees you can live there, because what you do when you do a life estate, but like you say, you live in the real estate world. So when you have a piece of real estate, you have what is called a bundle of rights, meaning
Yes.
you can live there, you can farm it, you can lease it, you can rent it to deer hunters, you can,
Right.
you can build on it, you can dig holes in it and mine it. You own it. You have all these rights that you own. So if you have this bundle of rights, when you give it away, you give it to the child. He owns it. But what you're doing is one of these rights in this bundle is you're taking out of the bundle and reserving it to yourself, which is called the present possessory interest, which means it's the interest now, and I'm going to possess the property. What the child has is all the other rights, but he's the remainderman is the name, and he has the remainder interest, or sometimes called the future interest. So you might want to look at it almost like he has a renter now that he can't do anything about, because they have complete use of the property. The only things that they can't do is commit what they call waste, which is like you can't trash it and ruin
Right.
it. But it's a present possessory interest, and it expires at their death, and it will expire worthless at their death. So, and at their death, now the remainderman, the child, now has all his bundle of rights have all returned to him now, and he has everything. He's still got the future interest, and now he also owns the present possessory interest at the expiration of the life estate. So
Yes.
that's a way to do things. Now, that triggers two things that come to mind. If you do that because you just want to do it, that's okay. But if you do that with this concern of long-term care in mind, there's two things that come to mind.
Yes.
One is it is a gift. So the sooner you do it and the healthier you do it, the better off you'll be, because once you give it away, you're starting this 5-year look-back clock where
Right.
if you do go into long-term care, you will be penalized. Actually, I call it punishment, and they call it penalty, but they will create a penalty period, which can be very long when you give away real estate, that will create a period of time where they won't pay for you. You have to private pay. And it's kind of axiomatic, because the whole reason you'd be giving the farm away is so you don't have to use that farm to private pay. So you're triggering that 5-year period. And you trigger that whether you put it in the trust or you give it to the child, like I'm talking about. And so you've got that. You're on the hook for 5 years.
Yeah.
Now, the other thing is when you reserve a life estate, it has value. And when you do that, the gift you give to your child is going to be something less than the full fair market value, because they have life estate tables in Title
Yes.
42 where you can figure out what it's worth the day of transfer.
Yes.
Now, not so much what it's worth what you've given to them is of concern, but what it's worth when you reserve it is what's a concern. That is an asset to you. And if when you're dealing with long-term care, they're always looking at countable assets. Or I always say if you want to understand the word countable, just insert the words available for cost of care.
Yes.
And that is. All right.
Yes.
Now that's a hard one to get rid of because who are you going to sell it to? If you come to me, a third party, and they say you want to buy my life estate, and it's like, well, I don't know how long you're going to live. How do I know what to pay for it?
Right.
Exactly. I might pay what the tables say, and you die in a month, and I seriously overpaid it.
Yeah.
And you may not want to sell it because you may outlive the life estate tables. So the only person that would even buy a life estate, in my opinion, would be the remaindermen, the people that have the future interest, because they it's in their best interest to do so. So it's an asset that becomes cumbersome during this 10-care planning process.
Interesting.
Because you can't give it away. If you give it away, you trigger another gift.
Yes.
And again, now it's really complicated to figure out what's the value of that.
So just to be clear, the life estate that one would possess, even though they've given the farm away or the property away, the life estate still is considered something of value.
Yes.
To the state.
I mean, they have economized that or monetized that in those tables.
Yes. Yeah, I've ran across this a time or two,
Yeah.
but kind of forgot about it because I don't see it that often.
The way it is let's say you do it now. You say, okay, my house is worth an even $100,000. Nice, easy number in your head, right?
Yeah.
And you go to the life estate tables and you look up and you say, okay, what's my age?
Yep.
You look under male, and you go to age, and your age is 70, and you go across, and there's two numbers. There's a column that says remainder, and one that says life estate, and they're fractions. And they will add up to 1 if you add the two together. So let's say it's 70, want to be 0.70, and they take it to like 6 decimal points.
Yeah.
Now, do they take valuing these things seriously? Well, all I can say is the table goes to 6 decimal places.
Yeah.
You know what that is in money?
Yeah.
It's like a fraction of a cent.
Almost nothing.
So that tells me, I guess they're pretty serious about that. So anyway, and so they'll say, here's what you're giving away, the 70%, and here's the 30% that you're retaining. And so they put value on that. Now, we can deal with that value if you have a life estate when we deal planning, but it is an asset that we have to deal with. And so, that's exactly how that works. And now, another disadvantage I see of that, and this is pretty much only of this method, and that is when you do estate recovery is when the 10-care will come after what's in your estate at death, okay? I think I talked about this a couple weeks ago, but estate recovery, there's two kinds of states out of the 50 states. There's standard estate recovery and enhanced estate recovery. We started out as a standard, which meant you can only go after what's in the probate estate. So the states that only have standard recovery, a simple solution is put everything in a revocable living trust, which is not in your probate estate because it passes outside of probate, and everything that's in it avoids estate recovery. Okay. The enhanced states mean they can come after anything in your estate, whether it's in a trust or not. Now, Tennessee started off standard. Sounds good, right? Well, we had some case law back in 2005, 2006, in Ray Estate of Smith, where our Supreme Court said, all right, we're going to kind of widen it from standard, but not go as far as enhanced. So we're referred to as a hybrid estate recovery. And here's the crux of that case, and that was if you pass away with an interest in real estate, it's in your estate for them to go after. So let's say you're in the nursing home. Well, let's say you're in a nursing home. You and your wife own a piece of property, and you guys own it as husband and wife. You have right of survivorship, right? It's Jeff and what's your wife's name?
Teresa.
Jeff and Teresa.
Yeah.
It doesn't even have to say right of survivorship, but it could. But if you're husband and wife, it's automatic.
Yeah.
And you're in a nursing home and you pass away. That is still, you had an interest, even though it's right of survivorship, where really at death all ownership vests with the survivor, right?
Yes.
Well, at death you had an interest in real estate, so now they can go after that.
Yeah.
If you have a life estate, guess what you have at death? An interest in property.
Yeah.
Okay. If you own it as joint tenants, like you and your son bought a piece of property, and you are kind of a 1/2 undivided interest holder, and he's a 1/2.
Right.
If it's your death, that is an interest in property.
Yep.
They can go after that half. Now they can't go after all of it, but with the right of survivorship, they can go after all of it.
Interesting.
So that's another disadvantage because when you put property into an asset protection trust, you don't have the interest anymore. Now you can control the property all day long. Somebody called me the other day. I get a lot of these calls, it seems like, where people say, I like this concept that people do. Sometimes they say wealthy people. Now, you don't have to be wealthy to do this.
Yes.
But it's the concept of I want to control everything but own nothing.
Yeah.
Yeah, have you heard that? You have. Yeah. Okay, now, when you first hear that, it's like, does that sound desirable? Maybe at first thought it doesn't, but that's kind of what we talk about. That's
Right.
how we avoid creditors. We put property in a trust, and it's in the trust. Now, it's our trust, and we control the trust. And we have all kind of control over the property. It's just not ours for anybody to come and take away from.
Right.
And so, and I mean, these, these have been around since the dawn. I mean, if you trace the trusts back to their origin, these exact trusts that we use today, if you want to research them and go back in time, pretty soon you get your feet wet crossing the Jordan River. I mean, they've existed in our jurisprudence from the common law.
Yes.
From the law, the Mosaic law.
Right.
So anyway, that's what we do. We put our house into this trust. Now we can control it. We get a chance to live there, and what we do is we create a right of occupancy. It is not a life estate, because the life estate is a thing with value, and it's an asset. This right of occupancy is not. It's a right to live there, but you don't have this division of ownership on it that they figure out. So that's an advantage. The life estate's not going to get in the way. Now, when any creditor, for that matter, tries to sue you, they can't get property in the trust because it's not. And they say, "Hey, I got a judgment against you. You need to sell this house and pay me off." And the answer is, I couldn't do it if I wanted to. The only person, it's my trust, but I don't have access to principal. Remember we talked about that,
Right?
And that no access to principal means it's really not mine to give you. I can't do it. It's not. I have no authority to do it.
Yeah.
But I get to live there. I can do whatever I want there. If I want to sell it, I can sell it, buy a new house, put the new house in the trust just like the old one. I can sell it and I keep the money in the trust. I can invest the money. If I do put money in the trust and not the house, just money, I can change the investment. I can, if you like to follow the investing world, you can put it in Home Depot stock. You can change it next Friday and put it into cannabis stocks. You think they're going to take off? They don't go very good, you can cash them out and put it in a managed account.
Right.
Where you get somebody in. There's a bunch on Edward Jones, Morgan Stanley,
Yeah.
Raymond James that'll just you give them money and they will invest it for you.
Sure.
And you can do that. I mean, you can control it infinitely. But you don't have this access to principal, which means the only thing that can happen is the principal cannot come out of the trust and go to you, the maker of the trust.
Yeah.
Now, we did talk about, the thing that makes the whole thing very palatable is there is a way for you to get access to principal. And it's not really access at all. It's exercising a right where you can distribute principal, an unlimited amount of principal to your heirs during life. It's a lifetime. And so you can distribute to your heirs, and they can turn around and use it on your behalf. So it's not access at all. It's the exercise of this right. Sometimes I refer to it as indirect access, but because the problem is, it's like, okay, we put property in this trust, and the trust says we don't have access to the principal.
Okay.
Well, the question is, can I still get at it if I need to? Yes, you can still get at it. You just have to do it that way.
Right.
And so that's the best of all worlds, in my opinion. I mean, it is a grand planning tool, and it is a asset protection trust from the get-go,
Yes.
a creditor protection trust. And guess who is going to be the biggest creditor that you're ever going to run into? And that is going to be the long-term care industry. Now, it may come in handy someday. You're sued. You're in a car wreck and somebody sues you above your policy limits. It may come in handy for that. But that's not why we do it. We do it because this long-term care concern is exorbitantly expensive. And if these assets are exposed, which they are if you do nothing, then it won't take long to consume them.
If you give an asset such as money to a child from the trust, is that considered income to them?
Good question. It gets asked all the time. As a matter of fact, it gets asked so many times that I actually put a slide in my PowerPoint toward the end. That is this question and the answer, okay?
Yeah.
But no problem. It's on everybody's minds, and that's what I like about questions.
Yes.
That's where your thought process goes, and you want an answer to that.
Yeah.
And the answer to that is it's not as simple yet. Well, the simple answer
It's
is
never
no.
simple, yes
is
and
no,
no.
it's not.
Yeah, okay.
But most people are interested in the reason why.
Okay.
And real quickly, the reason why is when you gift something to them from this, it's a gift. the trust is giving it to them. Okay.
Yes.
Now, the only person that ever pays taxes on a gift, I mean, the recipient doesn't pay taxes. The only person that ever pays taxes on a gift is the giver of the gift.
Okay.
Which is the trust.
Okay.
Now, the only time the giver of the gift pays taxes on a gift, here's where it gets is if the lifetime total of your lifetime gifts, if you sum up all your lifetime gifts plus the value of your estate at death, exceeds the federal exclusion amount, which right now, actually in just 2 days, right now it's 12.6 million per person, and it's going to 13.6 here as soon as we get to January.
So I can give my children $12 million without them being taxed on it as a gift.
That's correct. Right
Okay.
now, I mean that
That's good to know because I've got to do something with it.
Yeah, I know. Well, fortunately for you, my fee for giving you that advice will relieve you of some of that burden. Yeah. No, and here in this neck of the woods, I mean, I just don't get those kind of estates, and we're just good old folks. You know, we work hard all our lives. We have our nest egg, and you know, people have different sizes of nest eggs, but it's ours. And
I'm going to give them $12 million each.
and
I'm just saying.
And you got 8 kids, right?
Yeah.
Well, you know what? I'm a firm believer, even though sometimes I wonder if you leave your children a lot of money, if you're really doing them a favor sometimes.
Yeah, I wonder that too.
It just depends. It depends.
Yeah, it does.
But you know, you can leave it to them in trust, so they just don't. You know, if you leave it, let's just use that as a good fun example. You know, you leave your children a lot of money. You know, a couple million each. You know, one of them, most assuredly, is just going to go like get squandering and just go out and just live it up, buy a nice car, buy a house, and cut through it in a hurry, right?
Yeah, it happens.
And then kind of be sorry because 10 years later they might really need some money for something and they don't have the inheritance. You know.
Yeah.
So you can leave yours to them in trust.
Yeah.
And meter it out to them, especially if you know they're somewhat of a spendthrift.
Yeah, my son at this point, who's 12, as soon as he has enough money to buy something he wants, it's gone.
Yep. Yep. And you know, another big question is, does he work for that money and then spend it?
Well, yeah, we do make him do things and does work. But I've been hoping it'll soak in on him every once in a while that when he does that, it depletes his abilities a little bit.
But you know, here's what's happening with him. I'm not a psychiatrist, but I've seen it. As he earns it and gets it and spends it, he is learning.
He's learning.
And the day is going to come when he earns, some money, and he wants to spend it on something. Something's going to click, and he's going to look at the money. He's going to look at the thing he's trying to buy.
Yeah. And
what's going to come to his mind is what he had to do to get the money.
Yeah.
And now
that's the hope. Yes.
Now the thought process is starting to sink in. I can remember when I was young, I don't know, 19, 20, something like 18. I wanted to buy a motorcycle.
Oh yeah.
I ended up buying it, but I had, and all I had I didn't have, I had a paper route for years, and I had a job working summer jobs and stuff. So money was hard to come by. And this is back when minimum wage was $1.10.
Yes. Yes.
Anyway, I worked at a bowling alley.
Yeah.
Anyway, I think this motorcycle cost, I want to say, about $150. Can you imagine that motorcycle? It was a Honda 175.
Yeah.
And it was under 200, I know that.
Yeah.
But I had this stack of 20s. And I was getting ready to go buy it. And I can remember it as if it was yesterday.
Yeah.
Looking at that pile of 20s, because $200 in 20s is kind of a pretty good stack.
Yeah, that's a good stack.
And I'm a kid, I'm 18 years old or so. I'm looking at that and I'm thinking, I worked hard for that. I would do anything under the sun I could do to earn money. When I was younger and they wouldn't hire me, like less than 16, I'd be a golf caddy.
Yeah.
Put up with these arrogant, who's carrying their stuff for $5, then they give you a tip of $1 or something.
Yeah.
It's just, and I worked in a bowling alley, had a paper route. I did whatever I could.
Yeah.
And I stared at that, and I really contemplated the worth of this exchange.
Yes.
And of course, and that's what they're going to learn. At 12, it's just, at 12, the goal is the Estes model rocket.
Yeah.
Right? And that costs $10. That's the goal. So however I get $10, as soon as I get it, it's going for the rocket because the goal is a rocket.
Yeah.
At some point, the goal is going to be the financial part.
It took me a long time it took me a long time as a young man to finally get settled in on what I was doing and
Yeah.
what I was doing wrong with when it came to that kind of thing.
It's a process. Nobody
Yeah.
can do it for you.
Yeah.
You can advise
Gotta
them and
learn
help
it.
them along, but
You gotta learn it.
Yeah, and so I think you're doing the right thing. And he's got a defense, being 12 years old at this point.
Yeah.
He's still doing that when he's 25, and you might want to sit him down
That's
and say,
different.
"Look,
Yeah, that's different.
you know that conversation you're uncomfortable about having?
Yeah,
We're having it.
We're having that conversation. That's right.
Because I'm
That's
not
right.
working hard, so you can have a free ride."
That's interesting. That's good.
Yeah, but
Good
anyway.
deal.
Yeah, we got about 15 minutes left.
Yeah.
If anybody wants to call, that number is 766-9393.
Absolutely.
You can certainly call in with an experience or something you want to share.
Yeah.
It doesn't have to be a pointed legal question.
Yeah, absolutely.
That's okay.
I had a question go through my mind a minute ago, and it's lost me. Gosh, I was wanting to ask that, and now I can't remember. Maybe it'll come back to me.
Well, the door is closed, so it's still floating around in this little room somewhere. So it's got to
I'm
come.
sure.
It's got to come back in.
I'm
So
sure.
That happens to me all the time. It happens to me while I'm sitting here. I think I ought to have a pad over here because when you're talking, there's about 2 or 3 points you brought up that I wanted to address.
Yeah.
And I don't know that I addressed them all. So I ought to have a little pad over here and write those things down. Isn't that terrible?
I'll try to get you a pad over there. We can write.
Oh, I
something
bring my
down.
own. That'd be all right.
All
But I'm
right,
just saying,
okay.
Oh,
I know what I was going to. I remember now what I was going to ask you. I think.
let's go with it before you forget again.
No, that's not it. That's something I'll have to ask off the air.
Oh, okay, gotcha.
Anyway.
Yeah,
Well, those conversations need to be had.
they do.
It's all about seeing that what you have accumulated ends up in taken care of like you would like to have it, and your family will benefit from that, good Lord willing, and you will avoid a lot of trouble and possible conflict that we've seen happen, unfortunately, and it's just a wise thing to do.
It is.
To set your estate up in such a way that it's protected, and that your family knows what your wishes were and are.
Yeah. And when you're talking about what your family knows what your wishes are, don't forget what we call incapacity planning. Incapacity is when you're
Okay.
still alive, but you can't make decisions.
Yes.
Years ago, the time frame escapes me. I think it is in the early 2000s. The Terry Schiavo story. The gal that went into a coma.
Yes.
And
Yes.
after she was there they tried all kind of rehabilitation and stuff. I think it was about 2 or 3 months. The medical decision was she's brain dead and there's nothing we can do.
Yes.
And so the battle began. The husband claimed that we had talked and verbally, throughout, and they were married. She had expressed that she didn't want to be in this kind of condition.
Yes.
And so he was for do not resuscitate.
Yes.
And of course, in her condition, if they would pull the plug, she wasn't going to stay very long. Okay, she had
Yes.
machines doing everything. Well, her parents intervened, and they said, "No, we don't want that." Well, the battle went on for 14 years.
Wow.
Okay, and finally, the husband kind of prevailed, and they pulled the plug, and she actually lived without the machines for something like 10 days, but she expired.
Yeah.
And that created all this. Some people call it right to life, right to live, right to die, or how to age.
Yeah.
So that created our advanced care directive and what we call the power of attorney for health care. So what we can do is if something happens to us, like an incapacity,
Yeah.
we want to make sure we have trusted people named that'll make those decisions for us. There's two kinds. When you have power of attorney, and again, power of attorney is something that does not survive death. Those are lifetime powers.
Yeah.
And so Tennessee has bifurcated that power into two. One is for health care and health care only. And the other one is for everything else. So the one for everything else is commonly referred to as the financial power of attorney. It's also called the general durable, but it really is anything other than health. And it can get pretty close to health. Like if somebody's in the hospital and the hospital wants paid, the healthcare power of attorney has no authority to do that. The financial power of attorney does. Now, there may be one in the same person, but just to make the point. So, it's more than just finances. I mean, it is buy and sell, but it's invest, it's transfer, it's all kind of, you can do all kind of things with everything that's just not health related.
Yeah.
Then you got the other one that is these quality of life. And you can put right on the Advanced Care Directive what kind of quality of life you want.
Yes.
So, and they have them listed. I won't go through the language. A lot of people, if you've ever been to the hospital, you've seen one. Because if you don't have
Yeah.
one, they will ask you. If you go to the hospital, very soon they'll
Yes.
say, do you have an advanced care directive?
Right.
If the answer is no, they're going to shove a blank one in your face and say, fill this out.
Yeah.
And so, the language is there. Okay, if you have any of these unacceptable qualities of life, these are the resuscitative measures or the heroic measures. Do you, if you have them, if you're in this quality of life, do you want it? Like the first one up is, it's defined this way. It's called a permanent unconscious condition. That's the name of it. They define it as I become totally unaware of people or surroundings, and there's little chance of waking up from the coma. Now, notice they don't say zero chance. You won't get them to go there far, but little chance.
Yes.
So you're looking at a brain-dead vegetative state.
Yes.
Okay, let's just call it what it is.
Yeah.
Which is what they should have put on the form, but it's the state of Tennessee's form, and that's the language they use.
Yes.
And so then you have these heroic measures. There's CPR, there's mechanical life support, treatment of a new condition, and end-stage illness. And so tube feeding is the fourth one. And so it's like the question is, if I am in this, if I consider that, first question is, do I consider this brain-dead vegetative state an acceptable quality of life or unacceptable?
Yeah.
Most people think it's unacceptable. And you mark the box, unacceptable. So now if I need one of these heroic measures, let's use CPR as one.
Yeah.
So my heart stops. The
Yeah.
doctors say we can start your heart, and they can. They'll shock you, they'll thump you, they'll get it going.
Yeah.
But the thing is, it doesn't do anything for the coma.
Right.
So if you don't answer these questions right, you could be resuscitating yourself back into an unacceptable quality of life, which is what the whole thing is designed to prevent.
Yes.
So when they say CPR, they don't mean that in a vacuum. So in other words, let's say you fill one out and you mark, yes, if I need CPR, no, I don't want it, if I'm in one of these unacceptable qualities of life.
Yeah.
And then later today, you're over at Walmart and you just keel over. I mean, it doesn't mean that. We're going to shock you. We're going to thump on you. We're going to do whatever it takes to get your heart started, because you don't have the condition present. You're not in the brain dead vegetative state yet.
No.
And that people get confused with that. And they see CPR and they say, yeah, I want that. And they mark it. It doesn't quite mean that. It means, so if you have an unacceptable quality of life and you need one of these to stay alive, do you want it? Yes or no, is what the advanced care directive is. And so I always have people look at those and fill them out now while they're of sound mind and calm presence, and they can make the decision. If you go into the hospital and you don't have one and they hand you one, you're either bleeding or you're sick or something's wrong. And so you're filling the thing out right off the bat. You're not in your sound mind.
Yeah.
And so you're bleeding, you're hurt, you're not feeling good, and you have to fill this thing out. So we look at them, we discuss them, and you do it now while none of those issues are truly put down what you want. And that makes them enforceable. And so now the healthcare power of attorney does not cover every medical thing. So anything it doesn't cover, you're naming an agent, your power of attorney for healthcare purposes. And they're the ones, if it's not covered by that, they're going to make those decisions for you. So you want to put somebody in there, a trusted loved one that will. And then you also want to discuss with them, we're getting back to this discussion, what you do consider, what you would want to have happen. In other words, say, if I get this bad off, I don't want to be a burden to folks, and I don't want to be in that condition anyway. Whether I'm a burden or not, I don't want to be in that condition. Right. And so, these are my wishes. And, that can be uncomfortable to talk about sometimes with folks.
Yeah.
But, it is which is better? You go into this condition and them just not knowing what to do.
Yes.
And how about, I hate to bring the estate into it because it's not really a monetary decision, but you can't really ignore the concept that if somebody's in this coma and they're being kept alive, I mean, it's not going to take long to exhaust an estate in that situation. Correct. And the question is, well, we're just not going to pull the plug, or I know he said he wanted that, but I just, he's my dad and I just don't want to do that. Okay. So we got to pick people.
Not an easy decision.
It's not.
It's not.
And you got to pick people that
not an easy circumstance. Not at all.
Got to pick people that will be okay with those decisions. So you do need to talk because, you always got a kid that's kind of a bleeding heart and emotional. Yes. And you may have ones that are a little more practical. I always say, ideally, you have one child that's a CPA, and he'd be perfect durable general power of attorney. Yeah. And you have another child, the daughter that's like in the nursing profession and stuff, and she'd be perfect for healthcare decisions. Yeah, that would be great. Because when you're in that profession, you get it. You know what I mean? And you understand it. Hard decisions, yes, but you get it. Now, the point is, it's not their decision. You have memorialized it on the advanced care directive what you want. Right. So if you choose something else, here's what happens. If you put down all these are unacceptable qualities of life, and I don't want any of the heroic measures, and the person you name says, yeah, give him CPR and bring him back. He's in a coma, his heart stopped, give him CPR, bring him back. That's going to raise a red flag. Now the hospital's got some liability issues to deal with. And they're going to go with what's on the Advanced Care Directive because that's what came out of your mouth sometime when you were of sound mind to do it.
So the hospital will take the directive that you set up, not necessarily.
That's what they're supposed to do. Okay. There are some times when they don't do that, and I think maybe I mentioned this. I did on one of my radio shows where the hospital didn't, and they got sued big time, and it set huge ripples across the whole industry.
Oh, I bet.
To these medical people. We don't fill these out for the fun of it.
Right.
These are here for you to honor, and that's what you're going to do it. And so that was, but that's the legal precedent is they are to follow because it's you saying it. Your agent's just there to implement it.
Right.
But they also are there to make decisions on anything that the Advanced Care Directive is silent about. Yeah. So, if they know you like orange juice at 9:15 every morning, they can make that decision, have that brought into you. I mean, you know what I mean? And so the point is, when you're planning, it's not just after death. It's incapacity planning because not everybody grows old, becomes incapacitated, and dies. Some people just grow old and die, but some people grow old and get incapacitated. When you have an incapacitated person in the family, you want this planning in place because if you don't have it, you have one remedy and one remedy only, and that is a conservatorship.
Yeah.
And I call a conservatorship a court-ordered power of attorney because the only person that can do this involuntarily is the court. Yeah. And that is a big deal. It's very expensive, for one, and it takes 5-6 months to get it done.
Oh, wow.
I had to fast-track one once, and I think we got it done in 90 days, but it just it's hard. Wow. So anyway.
Wow. Well, to review the morning, and we're about to wind up here in just a couple of minutes, I did want to, we talked about, first of all, this is not necessarily an easy thing for people to talk about sometimes, but it's a necessary thing. It's something that you consider necessary with your family. And you make it easier by bringing the facts forward on what's available to us. And that's been very educational for me. That's been a good program. But we're winding up the year, winding up the program, and of course we want to put your contact information back out there and the fact that you've got another seminar coming up.
That's right.
I want to review that right quick.
Yeah, the next seminar coming up is going to be up in Franklin. Nice drive if you want to come. I'm not sure when the next one's going to be here. I didn't check. The girls set my calendar, and I'll have to check. It's probably on my calendar if you go to my website. But anyway, it's going to be 2 weeks from tomorrow, which is January the 13th.
Yes.
It's a Saturday. We do those at 10 o'clock. It's going to be up in Franklin at a place called Suite 501. Its physical address is 416 Mary Lindsay Polk Drive in Franklin. You're welcome to come to that. It's called Will's Trust of the Nursing Home, and that's what we talk about. If you want to talk to me about anything in particular, give me a call. My Pierchoski Estate Law, Pierchoski Elder Law, and my number is 931-363-7222, or you can go to my website, Estate Plan Stan. That's not state plan, that's ESTATE, estateplanstand.com. There you can see the calendar. There you can get my email if you want to ask a question that way. Or if you didn't write the phone number down, you can get it when you go there. And you can call me. Call me and schedule one of my 15-minute phone calls, and we'll talk about your question.
Absolutely.
And I'm more than happy. And I don't. There's no charge for that. I'm more than happy to give the time for questions because people have questions in this area of the law, and they need answers, and I'm there to be a source for that. And then you decide what you want to do.
Absolutely.
If I can be of help. So
always a pleasure, and of course we're winding up the year. Wish everybody a wonderful and happy New Year's. You got big New Year's Eve plans and all that?
I do not. I'm kind of a low-key guy on New Year's.
Well, us too. I kind of just coasted on in. And look forward to it. Now, you're planning to be here next Friday, I guess?
Sure, I'll be here next Friday.
Good deal.
And I always say at the end of some of my radio shows, doing nothing gives a predictable result.
That's right.
So, doing nothing, I guess, is a choice, but not necessarily a good one.
Not a good one.
It's always a pleasure, Jeff, and we've been doing this since June this year, so we'll start it out with a bang in 2024.
Learned a lot. Looking forward to next year. Thank you, buddy.
You're welcome. Thank you.
If I can get this thing to turn on for me, should be going right now, but it's not.
Do I need to sing?
We might. I wonder why it's not. It says it is, but it's not.
Well,
very interesting.
You know how those computers lie.
So it's given us some extra time this morning for some reason. There you go. Hey man, thank you for being here. I'll see you next year.
Always a pleasure.
Broadcast services of Prospect Communications.
She removed Trump. Now Republicans want to remove her. I'm Dave Anthony, Fox News.
She opened the door to election chaos. I really don't think that we can have somebody as partisan as Shenna Bellows being in charge of our elections.
So Maine State Representative John Andrews tells Fox he wants to impeach their Secretary of State for blocking the former president from the 2024 GOP primary ballot. Shenna Bellows tells MSNBC.
The events of January 6, 2021, which were unprecedented and tragic, were an insurrection.
So she says that disqualifies the former president, citing a provision of the Constitution that was meant to block Confederates right after the Civil War. But former